let's meet our distinguished judges. First off, we have Attorney Bernadette Lim. Next, we have CVC Law Partner, Attorney Franchette Acosta. And our Chief Adjudicator, Judge Grace Chavez T. from the Municipal Trial Court of Lipa City, Batangas. Tonight's proposition, let it be resolved that Republic Act 8479 or the Oil Deregulation Law is unconstitutional and void for vagueness. Starting off for the affirmative side, arguing the need to scrap RA 8479 is Jams Giducos. Jams, you have 4 minutes.
Your Honors, opponents, ladies and gentlemen, Assalamualaikum warahmatullahi ta'ala wa barakatuh. High oil prices in our country is one of the most pressing issue. The oil deregulation law, since its enactment in 1998, promised to promote a competitive environment that would lower down the price in oil industry and provide better service to the public. But after 12 years of deregulation, this promise of the law is nowhere to be found. Thus, it only paved the giant oil companies to earn bigger profits, and the entry of the new market players in the industry do not mitigate the problem. Thus, the adverse effect is the underprivileged Filipinos are primarily affected of these concerns for the reason that it makes their budget tighter than before because the high prices of the commodities brought by the oil price hikes. Unquestionably, these existing problems is a result of a failure of the oil deregulation law to prescribe standard on fair pricing. Thus, the affirmative bench vehemently stand against the status quo. It is necessary to declare RA 8479 unconstitutional and void for vagueness on the following grounds. First, allow me to point the vagueness of the law. Republic Act 8479 includes penal provisions on anti-safeguards policy to protect the public from monopoly, unfair market competition, and cartel. But first, we need to resolve whether the oil deregulation law has a definition and guidelines for determination of fair price that will set into motion the enforcement of these antitrust receive provisions. The answer, ladies and gentlemen, is in negative. Nowhere in the letters and spirits of the law which lay down the parameters of fair pricing, which in effect puts the public open to abusive oil of the oil companies because it becomes their sole discretion to determine the reasonability of oil prices without any standardized pricing formula.
So your proposition right now is that the whole law is actually unconstitutional and that you're not referring to any specific provision of the law.
Because ma'am, our proposition is parallel to the objective of this debate. And scrapping the whole law is thus immediate answer. Second argument. In the case of Connolly versus General Construction Company jurisprudence which explains the void and vagueness doctrine, a statute is void for vagueness when it lacks a comprehensible standard. First, it is repugnant to the Constitution. First, it violates due process. Republic Act 8479 actually failed to impose fair notice of the conduct to avoid. This law, so it would be unconstitutional as to warn, because it actually failed to impose fair notice.
Certain provisions of the law, such as liberalization, preventing anti-competitive acts, so that the fact is that you can derive the meaning, although not directly or expressly.
But ma'am, under the deregulation law, this kind of problem is still rampant. In confronting with the status quo, this side of the house.
All right, you can continue. You've got a few minutes, seconds.
The Filipino in general are the principal stakeholders whenever oil prices keep on changing, and therefore, government should step in to effect the necessary measure to impose comprehensive fair mechanism under the oil products to safeguard the public against cartel, monopoly, and unfair market competition.
Thank you, James. Alan, 2 minutes to cross-examine.
Mr. Speaker, are you aware of the fact that there is this declaration of policy in RA 8479 wherein it is being emphasized that the purpose of this law, the purpose for its being created, is to liberalize and ensure a truly competitive market? Do you believe in that?
Yes.
Are you a believer now of this policy where, in fact, 12 years have already passed? Have you ever seen a growth or a development in the oil industry since 1998?
There are entries of new market players,
Yes.
and the oil giant companies.
So you agree that there is this entry of new oil players?
Yes.
Do you believe that there is a big change or a big development or a big growth from the 1998 economic status up to now in 2011?
No, because the problem...
Do you believe in do you know the concept of liberalization and deregulation?
Yes.
And as a matter of fact, do you believe that this oil deregulation law itself promises a truly competitive market in the oil industry?
Yes.
And in fact, if you have a competition, you would have a fair price as a product of this competition. Do you believe in that?
No, because there is
Why not?
because in our current setup, although there is competition, but the problem is there is oil price.
Do you
hike.
agree that fair price can happen or can exist in any industry, not just the oil industry?
Yes.
So you agree now that fair price cannot be defined in a law. Thus, it is not a legal concept.
Nowadays,
No, yes or no, Mr. Speaker?
yes.
Yes. So, do you agree that we should define fair price in this oil deregulation law? Do we need to define
Yes,
fair
it
price?
is indeed necessary.
But again, does it make that law vague to become void or to become unconstitutional?
Because there is no parameter laid down in the law.
But there are also provisions that punishes by acts or violations of the Constitution in that law. Do you believe that there are also other safeguards?
All right, Alan, 4 minutes to rebut James and argue the need for the oil deregulation